Okay, hello everybody. Hello. Welcome to today's live panel discussion, Transforming the Litigation Lifecycle, Integrating Information Governance and eDiscovery to Reduce Costs. I see folks trickling in. Thank you for making time to join us live. I know it is probably lunchtime for folks and/or late morning for those on the West Coast. I also saw a couple of folks on the international side. So thank you and welcome. Feel free to drop in the chat where you are joining us from. It's always very interesting. And bonus points, your favorite team. There's always some friendly sports competition going on. And we'd love to know. So we will just let everybody kind of get in, settle in, and we will start in just a minute or two. Okay, there's folks from Canada here. We will be at ARMA Canada in just a couple of weeks. So we're excited. And personal fun fact here, I was born and raised in Ottawa. So hello, Stephanie. Okay, I don't see any sports rivalry yet. Feels like people are still staying friendly in the chat. Okay, we are just about a minute in, and again, welcome everyone. I see some familiar names, but if you do not know who I am, my name is Kim Tran, head of marketing here at Gimmal. I am very excited to host today's live panel discussion along with our partners at Cooley and CloudNine, and my boss, Dean Gonzalski from Gimmal, CRO here. So with that being said, let me take over and share screen here. Okay. Alrighty. So a couple of housekeeping items before we start. Today's agenda, we've got a packed agenda. We have 3 esteemed expert speakers today, which I personally know as well as professionally, and some of you all may have heard them speak at various events and conferences as well. And so on today's agenda, we will kick off with introductions from everybody. We will have really across the spectrum of the EDRM model perspectives and lenses from the IG side of the house, going all the way to the right on the eDiscovery side with CloudNine. We will talk about also the intersection in reality of who owns IG and eDiscovery practices and how those two functions and industries have converged, have evolved, and where future trends, for planning and strategizing for everybody will go. We will also be discussing very specific areas and themes across the life cycle. So starting from data identification, collection, review, and finally production. So while we do have a live Q&A portion at the end of today's live panel, we do encourage you that if you hear something that resonates in real time or needs clarification, or you're just curious about it and want the panelists to expound on things, please feel free to use the Q&A function. This should be, depending on how you have your Zoom settings set up, this either will be at the very top or the bottom bar for you. The chat is always open as well. So if you have any comments, feedback, please feel free to share in real time as well. So about us, Gimmal is information governance simplified. We are the market's only end-to-end information governance solution. We help enterprises as well as local, state, and county governments and educational entities and institutions tackle mission-critical information and data governance challenges. So not just for today, migrating off of legacy systems, but also planning for the future, especially as laws and regulations get more complex and the landscape is accelerating and evolving at rapid pace. CloudNine is our esteemed partner. It is a SaaS-based eDiscovery platform with self-service processing, analysis, review, and production for both traditional and modern data. Joining us from CloudNine today is Rick Clark. And then Cooley LLP is an international global firm with over 1,300 lawyers across the world. And they specialize in partnering with clients on very complex IP and regulatory matters, litigation as well. And so joining us from Cooley today is Matt Kringle, and we are excited to dive in. Before we start, because we have attorneys in the house, again, disclaimer, this is just for informational purposes only today. As you know, we will be recording and sending this out. You can also watch on demand on our YouTube channel after today's live webinar. But this is not legal advice, and just please keep that in mind as you ask your questions. So without further ado, please meet your panelists today. Dean Gonzalski, Chief Revenue Officer at Gimmal, Rick Clark, VP of Strategic Partnerships at CloudNine, and Matt Kringle, Discovery Counsel, Director of Information Retention Counseling at Cooley. Dean, would you like to kick us off in terms of intro?
Yeah, thanks, Kim. I'll jump in. So you mentioned real practicing attorneys here on the call. I am no longer one of those. So if you want to listen to my advice, feel free to take that, but it is not subject to any of the bar associations I'm no longer participating in, which used to be California and Colorado. Been in eDiscovery for 20 or so plus years, and that's morphed into information governance. And so I'm excited to share kind of a lot of the intersection and practical tips, tricks, best practices that we see out there. The perspective I'll mostly share a little bit in contrast to Matt's, which is going to be more sort of legally oriented. Mine's going to be more technology oriented in terms of how do you take what is a regulatory framework or an eDiscovery framework, and how do you institutionalize it within your organization and make it actually happen? Because a lot of this is fine on paper, but a lot harder in practice. So happy to be with you. And I'm calling in from San Diego today. So there you go.
Awesome. Thank you, Dean. Rick?
Yeah, thank you, Kim. Rick Clark with CloudNine. I've been with them for about 3.5 years. It was through an acquisition, had started the company ESI Analyst back in 2018. And it was all around modern data. But I've been in the industry for over 20 years, co-founder of the Masters Conference. And so I've really played mostly on the right side of the ERM, on the technology side. So my contribution today will be mostly around technology and workflows that I've seen where, as we continue to grow and develop into solving some of these bigger challenges with these new data types.
Thank you, Rick. Last but not least, Matt.
Thanks. Hello, everyone. I'm Matt Kringle. I am Discovery Counsel and the Director of Retention Counseling at Cooley. My practice that I run focuses on helping clients to govern their information. It touches on privacy, compliance, records retention, data security, all of the things that kind of lead into eDiscovery, which I actually have a lot of experience with in a previous career. I've been an attorney for about 20 years, focusing on litigation, eDiscovery, information governance, and I think this is probably one of the most exciting times when it comes to just information governance in general and eDiscovery, based on the challenges that I'm sure all of you are focusing on and wrangling with, but us as well. And I think that makes for a very, very exciting time. So with that ado out of the way, let's kick it off.
Yeah. Well, thank you. And as Rick mentioned, in terms of models, and Dean alluded to this as well. Models and frameworks are great, but the real world and in practicality, things are changing so quickly. And so here is the eDRM, left side of the house, managing information governance. And as we move towards that framework and model, then it becomes eDiscovery, which is, Rick's side of the house. And I'd love to kind of have Dean kick off in terms of where was this model 25 years ago and how has it evolved today?
Yeah, I'll jump in because you asked 25 years ago. There wasn't this model. And it's funny that self-deprecating story. I was talking to George Sosa, who's the one who created this, and he said this was like in early 2000s, and he said, I've got an idea to create a reference model for eDiscovery. And I said, George, that's ridiculous. We don't need that. Which goes to show how smart I am and all the disclaimers about my advice today. But there literally wasn't a model. There was Sedona Conference, and you would kind of draw up how these kind of things worked. And so the eDRM really became the lingua franca for understanding kind of where your company fit and your solution and your problem and where your people and your dollars all went. And so that's been really helpful. I think one of the challenges, and I'll pivot to, I won't talk about eDRM proper too much, but from a discovery standpoint, but from a governance standpoint, it's a lot harder. As you can see, it's not this linear, we have a thing that drives us, eDiscovery is nice in that there's litigation, and litigation causes you to sort of lights a fuse, and then stuff must happen, more or less. Governance is more of this like way of life. And because of that, and it's also circular, as the graph shows, with lots of different stakeholders. And that's, again, another challenge in contrast to eDiscovery, right? eDiscovery tends to be just more legally owned, and that the attorneys and litigators care about that process. Almost everybody cares about IG, and the different lenses that they look at that problem really cause a little bit of the blind man and the elephant story. I don't know if you guys have ever seen that, right? Depending on which part of the elephant you touch, it looks like a different animal. And so from an IG perspective, you have people thinking about information security, data protection, and from a privacy standpoint, you've got DSAR, and you don't want to keep too much information. You've got data minimization. You've got risk exposure in the sort of surface area for the InfoSec people. Then you get the business stakeholders who want to have access to the data, and then records managers want to keep things according to record schedules. And so it's really hard. It certainly is being done and can be done, but compared to sort of a very linear fuse lit eDiscovery model, it's got to be much more holistic. And that's why you see the people who are really good at this tend to be more heavily regulated, because this is a big issue for their company. And they have got a long view of this. They know that information continues to be a challenge, will always be a challenge. It's never getting smaller or easier. And so for us, we'll talk about this as we go, but I would think of this in a weird way as IG subsumes this whole slide, and eDiscovery and a lot of various processes are inside of it versus just on this far left-hand side. So here you'll hear about us talk on left-hand side and right-hand side. So left-hand is really sort of way upstream of eDiscovery. So that was probably longer than I meant to go, but I don't know if my panelists want to critique any of my comments there.
No, I think that's spot on, Dean. I mean, you mentioned that sort of the genesis of this. It was much simpler then, right? It was linear. Now it's horizontal and vertical. So, and I think if you just even look at the information governance side, not to belabor this, I mean, it's complex. I mean, that's a wheel within a wheel within a wheel within a Venn diagram. I don't know, but all of these things are considerations, and all these things that are considerations before, as you mentioned, sort of the legal trigger, right, or the POW, as I call it, the starting gun for litigation, which changes things and the dynamic. All these things then flow into the way that you handle eDiscovery, right? We talk about security and privacy. Well, when you're sending out information as part of an investigation or litigation, you're producing documents. Those are concerns, right? Privacy is a concern now, which it really wasn't as much of a concern 20 years ago or 15 years ago. So I think you did a great job. Let's move on and really dive into sort of the practical applications of this and some of the things people must be wrangling with.
Yeah, I think like you mentioned, the framework is great in theory, but in practicality, you throw in people in the midst of process and, frameworks and models. And I think regardless of industry, regardless of organization, company size, silos have been a huge detractor of real collaboration. And so obviously, as IG and eDiscovery are now intersecting, we're seeing all these different teams kind of having to join and work together. And I'd love to hear, both of all of your perspectives and your experiences dealing with this.
So I can jump in here, since I think what we see on the right side of the EDRM with eDiscovery is that a lot of the data that we're seeing is changing, right? So our habits from email are switching over to Teams and Slack and sort of other corporate communications. And so because we see these problems surface in typically a very fast fashion, meaning we've kicked the can on Slack or Teams, and now we absolutely have to produce this, then it turns into this very fast moving thing. So one of the themes you'll hear a lot today is that on the IG side, having the better policies or the right policies in place for your organization, having the right processes, those things will help if and when these data is getting introduced to the case, whether it's an investigation or discovery. There has to be a good handle on this. Otherwise, it has turned into some pretty expensive, and it takes a lot of time to manage.
Yeah, Rick, let me pull on a thread you just had there. I think it's maybe sort of axiomatic to us because we've all lived it for so long, but to point out kind of for the audience, eDiscovery is fundamentally reactive. Like, you don't do anything until something triggers it, reasonable anticipation of litigation. There's a tension between that and people, and if you don't get sued all the time, it's very easy as an organization to say, like, we're good, everything's humming along. And so you've got this reactive process that kicks off, hair on fire, everyone's really worried and concerned and got to go do stuff. And then you have, on the governance side, it's much more proactive, and you need to be planning in the absence of any of the reactive things. And so that, to me, is one of the sort of huge tensions here, is that it's easy to be reactive. We all think about reactive at deadlines, and that's what, forces us to do things, right? The sheer panic of litigation and eDiscovery is good. So it's a wake-up call. It's a lot harder. We hear about vitamins sort of versus aspirin, right? You take aspirin, you get a headache. That's a more reactive pain sort of solving sort of notion. And then taking vitamins and exercise and eating healthy is just harder. It is. And that's really the way governance is. But when you don't do that, and it's a theme, as Ricky said, we'll continue to hear, makes it a lot harder to respond in a critical hair on fire situation, because you have, and I don't know how much we'll talk about data maps, but as an example, you need to go collect from custodians. You need to know who the custodians are and where their data exists and resides organizationally. It's very hard to do that reactively because you just don't have time, because there's all these rocket docket and sort of timelines that happen in reactive land. And so a lot of this becomes, if you're not proactive, you can't be reactive properly. And I don't know if that makes sense, but I think there's a real strong tension there, but organizationally, between how people want to spend and prepare and hire and staff and all that. We see played out all the time with organizations.
And even adding to that tension, the FTC and DOJ just recently, semi-recently announced that both agencies are updating their language to their standard preservation letters. And the statement they made I found to be very interesting and fairly aggressive. And opposing counsel is doing a lot of the same things. So this data that we're going to be talking about a lot today is here to stay. But the quote from the FTC website: "These updates for legal process will ensure that neither opposing counsel nor their clients can feign ignorance when their clients or companies choose to conduct business through ephemeral messages." And this is through the Manish Kumar, Deputy Assistant Attorney General of the Justice Department Antitrust Division. And then he further says, "The Antitrust Division and the Federal Trade Commission expect that opposing counsel will preserve and produce any and all responsive documents, including data from ephemeral messaging applications designed to hide evidence. Failure to produce such documents may result in obstruction and justice charges. Certainly that's a far extreme of things, but certainly highlights the importance of all of this. Opposing counsel, though, is asking for this data as well. So really, it is important to, yes, we have email and corporate documents under control. It is important to start figuring out what other pieces of data are going to potentially be important to investigations, compliance, and litigation.
Yeah, and Rick, I don't want us to get stuck on the slide, but we might have to, because I think there's a key point, Rick, here, which is we think we have email and documents under control. I will tell you from my perspective, 99.9% of the corporations don't have email and documents under control. They have them under better control.
Okay.
And the newer, more modern data and ephemeral messaging and Slack and Teams is a bigger problem. But we talk to people all the time who have just plain old garden variety file shares with just lots of data in it, no idea what's there. And you would think that's pretty easy to solve. And it is technically easy to solve. They just haven't solved it.
Yeah, I'll weigh in too, and not to belabor this, but I think it's going to lead into the next slide nicely when we start talking about sort of the variety of information. So what you mentioned has been long-standing and going on for a bit with the DOJ, FINRA, the SEC. They've been long wary of ephemeral messaging applications. Well, I should say features, because a lot of applications are not necessarily ephemeral in nature. Some are, some aren't. But some offer
for folks
features.
who don't know, describe what ephemeral messaging is.
Yeah, sorry, we've been talking as if, so ephemeral messaging is I think most likely you think of Snapchat because they were the first ones to kind of come up with this notion of disappearing messages, right? And there's a utility in it, that obviously with privacy concerns, not keeping information around forever has a practicality to it. The issue with regulators and the scrutiny we're seeing, and every conference they bring it up. The most recent you read about, but they've issued guidance on this for going on like 4 or 5 years. Is that they're wary that people are using them to skirt rules, and in particular, leadership, executive teams, employees, to skirt preservation obligations. With heavily regulated industries, financial services, et cetera, where there's record-keeping rules going back to the 1940s. They call them off-platform communications are really concerning because it circumvents the need to preserve. It's tantamount to a phone conversation, the difference being the phone conversation is sort of ethereal and disappears in the ether. When you have a chat, you're actually putting it on some medium. So they've been very wary about it, and now courts are also. Does that mean these applications are in general bad? No, they have a utility. There is a reason to be using them. But I think it really speaks to what we're going to get into, the complexity of information within a company, and the need for policies and acceptable use standards and codes of conduct. That's another thing, is a lot of these find their way into litigations, even if they aren't ephemeral. And the way that people speak in a chat, as opposed to an email, typically is a lot more informal. And what can happen is that can be misconstrued when read into evidence. So around these sort of short form messages, these chats and things, you really want to have policies. And we're going to get into sort of how policies can help in information governance and in general with eDiscovery. And we're kind of at a tipping point where it's almost death by policy, right? I mean, companies have so many policies that it's almost too much noise, right? You can't discern the signal from the noise. But in this case, based on what we're seeing from the regulatory scrutiny, they're necessary. So that's something we've helped clients write policies as to what's the acceptable use for applications. If you do need to use an application that's not supported by the company, and there's use cases for this. If your client will only use WhatsApp or Signal to communicate, I mean, you don't want to lose a sale over that. So you need to sort of have exceptions, but parameters and guardrails around that. But I think this leads nicely into our conversation in the next slide about the volume, the variety, and veracity. Do you want to kick us off, Dean?
I can. I thought Rick was going to, but that's okay.
Yeah.
Oh, my apologies.
I can.
Wait, we have a moderator, Matt.
No, I was just gonna say, you guys, painted the problem. We know it's a tipping point. We know what the problem is. I think here, I think the issue now or the conversation now and the people want to know, how do we address the problem? How do we fix things? And so this is a great segue. Anyone can chime in. I'm the moderator, but I'm not going to,
Sorry, I disempowered you, Kim.
But I actually can jump in here because it goes back to you typically know and you have policies needing updating when a new data type is introduced or required for an investigation or discovery, right? So, but let's talk about the volumes, variety, and veracity here. So volume, we know, continues to grow in general, and that is across the board. That's email, that's files. At CloudNine, we create documents all the time, and I'm like, why can't we just consolidate? But regardless, there's data growing all the time. Well, the variety of data is really where we're finding the bigger challenges, because many companies are switching over to more of a corporate, chat applications instead of email. We're finding that is becoming very necessary for litigation. But it's not just that, right? We're looking at text messages, phone calls, voicemails, could be memos, could be geolocation, or even social media. There's just such a variety of things. Now, I will say, most everybody who's on this call today or watching, what challenges you're having. What or maybe you don't. Maybe that's part of why you're here. But start paying attention to what potentially could be a part of a case. And I will just say, from a general standpoint, it is the corporate chat applications. It is the cell phones, right? Those are becoming the most growing needs at a corporate level. Employment law and others gets into the social media, and we can go down all sorts of fun paths. But and then the last one, veracity. I am finding that the standardization on which companies are communicating is at least sticking within a particular type. So the growth of new applications that are being adopted at the corporate level are starting to, we're finding the ways to get in. Like, so early days when I started in eDiscovery, it was GroupWise, NSF, and PSTs, right? So we had to, figure out how to manage all that data. Well, now we are just sticking with the PSTs and with Microsoft. But so similar points being made with veracity here. Yes.
Yeah, and Rick, maybe just I think this is sort of the nuclear escalation. Data types will always continue to proliferate. And I think what's interesting is that the bad behavior or exculpatory behavior or interesting stuff tends to be on the newer forums, because people know at some level, like, I shouldn't write a really offensive email on my corporate email system. Matt kind of raised this earlier. But yeah, once I'm on Team or Slack or using a text message or ephemeral message, I'm free to just wild, wild west and say and do a bunch of ridiculous things. Why? I'm not encouraging that, by the way. But that tends to be sort of the practice. And so then what it means is that the lens for really all the interesting data is found on all those newer things that are coming out. And that's why this sort of escalation, it's hard for people to sort of keep up with that. We don't need to keep up with it per se, but that's where the juicy stuff is, I guess, is where I'm leading to that conversation.
Yeah, we had a case where we exhausted everything. We exhausted email, text messages, and it wasn't until I don't know how we got there, but we expanded out into Twitter direct messages. That's where the meat of everything was. So, and this was an investigation, so there's a lot more freedom in sort of spidering out generally, where arguments can easily be made. But in discovery, we're finding a lot of the same things. The arguments are getting made to go after and include this data from both opposing counsel and certainly government agencies.
Rick, or any of the panelists, do you find that this portion or phase is probably the most costly or resource intensive, or kind of other stages of the litigation lifecycle?
Curious on what Matt and Dean say. What I have experienced, because we typically get oh my gosh, we have to do all this data. Like, we have to figure out what we're doing here. So we're jumping in the fast. It's more eye-opening. It's more of the, like, oh my goodness, there are more data types than I ever thought that could be impacted here.
Yeah, I would say volume to me has always been the historical, like we have massive amounts of volume, and the more volume is more problematic for processing and eyes on review and hosting, and volume is bad. I think where I'm sure you guys see this is that the variety is problematic because if you just had like billions of email messages, yeah, we're getting pretty good at that. When you combine email messages and text and ephemeral message, all this stuff, Rick was just now you have like different forms of things, a bunch of apples and oranges that you're trying to review simultaneously. And I think the different modality there causes its own different kind of pain. It's not the volume then anymore. It's a combination of volume and variety is kind of a double whammy.
Yeah, and I think even from another cost perspective, the most of the spoliation sanctions and the motions to compel are around text messages, around BYOD, personal use of phones, and sort of the commingling of business information and personal information, access rights. We're seeing those are the vast majority of the cases now. So from a cost perspective, the cost of potentially, adverse inference instructions or case ending sanctions, that's also a consideration. Another thing that I think, is worth touching on, and it's not on our shores yet, but it's coming, is the veracity element, which, I mean, forged evidence has always been a thing, dating back to the first time somebody forged a document and tried to pass it off as authentic. But now we're into a whole new generation of potential fraud or forgeries with generative AI, right? So some of these deep fakes, and I've seen, a couple webinars and a couple demonstrations on this, and it's certainly something that the regulatory agencies and the CIA and the FBI and all the IA agencies are concerned about. The level of realism has ramped up, with the growth of AI, and so we still have the Daubert standard, which judges will allow. Whether an expert it can give qualified testimony, but we're going to see a lot more experts having to give testimony on whether evidence is fabricated or not. But beyond that, and the burden's always been, on the receiving party to raise objections for evidence that might be not non-authentic or inauthentic. But you also have ethical and federal rules. The rules of evidence 901 and 902 require attorneys to produce evidence that's sufficient to support a finding that the item is what the proponent claims it is. Usually you can use circumstantial evidence. Obviously, with generative AI, that's going to be more difficult. And then there's ethical rules that you need to take reasonable steps to avoid presenting fake evidence. So conceivably, you're going to need to be able to authenticate your evidence before placing it into evidence. And with the ability to take a picture or a video and alter it to seem as if it's an authentic, real deal item as evidence, that's going to be a whole nother consideration when you start talking about the timing. You mentioned how quickly litigation proceeds and how difficult it is with the volume and all of the items that need to be done. But now you've got to add in this element of, do we even know that the evidence that we're presenting is authentic? So there's a whole, obviously a whole lot of considerations, but that one is, I think, going to be one that takes is going to be concerning for a lot of parties as these generative AI technologies really become more mainstream.
Yeah, thank you, Matt. I think this is a good segue into, preparing and getting ready for litigation. And Dean kind of alluded to this, where IG has been proactive, whereas eDiscovery is more triggered and reactive. And so, for the audience, what role does IG play so that we can ensure downstream preparedness? And I think this is also another phase across the life cycle where it costs a lot to be well prepared.
Yeah, I'm sure you guys have seen this tons, where as we said before, the fuse gets lit. We've got 10 custodians, and it's go collect their data. And then the question is from where and what and how and who, and all that spiders very quickly into sort of chaos organizationally. So I would say step one of information governance, and I mentioned data mapping kind of before, but that's even a little bit more tactical, is sort of just know what you know. Understanding your different types of systems that are out there, who has access to them, how they're used, how they retain or don't retain information, and conceptually how, if I wanted to get something out of that system, what would I do? That's really hard, as I said before. It's hard to do on the fly under the sort of the scrutiny of litigation, because you have time constraints, A, and B, if you mess it up, which happens even innocently, it'll tend to look bad, right? There's a scenario where you're like, I'm not sure how and I don't even know this, but I know there are different policies on this, but with Teams and Slack and things like that, you believe you can set various retention parameters. Well, let's say you're messing around with, or your head of IT is messing around with those in the context of a piece of litigation and deletes whatever they have or changes the policy around or moves it, and all of a sudden that looks really bad because you didn't do it ahead of the litigation. You did it during, and it may be innocuous, but it may look bad. You may have some, Ricky or Carter, you may have some splaining to do, and that's going to be hard. And so I would say just the awareness of organizational sort of data structured in silos and permitted systems is it's not information governance per se, but it's certainly part of that discipline.
Yeah, I'm going to tie on to that. That's precisely, I think, the biggest issue that we see is that you can't anymore just do this with no plan in place, right? When we were talking about boxes of documents and not terabytes of data, yeah, you could probably, oh, we're being sued, we need to preserve A, B, and C. You could identify it, but we talked about it. The volume just does not allow it. So one of the things that it's, to me, I feel like it's sacred, it's fundamental, that you want to have at least a process, formal or informal. Better to have a formal process. And so one of the things I tell my clients is, and it's really kind of low-hanging fruit. It's easy to implement. It's easy to draft, is a legal hold response policy or procedure, right? For if you have an in-house legal team, or even if you don't, right, to sort of direct outside counsel, just having a formal plan has a myriad of benefits, right? They say failing to plan is planning to fail, right? So if you have actually a conceived plan that when litigation or investigation begins, when is that legal trigger, that you need to preserve, because there's a reasonable anticipation of litigation or of investigation, that you can follow a set of processes. One, just practically speaking, that's great, right? You're going to be able to pull together the stakeholders, IT, HR, departing, when they're dealing with departing employees, legal, and the other stakeholders. You're going to be able to better scope. But beyond that, from a defensibility standpoint, you're going to be able to better explain what you did. And ultimately, when we're talking about spoliation, we're talking about loss of evidence, the standard is reasonableness, right? So having a plan is going to lend into that reasonableness. The second thing is it's always adjudicated looking backward, right? What were the steps they took? If you're able to say, we have a process, we followed that process, we were very contemplative in implementing that process in the first place, that's going to put you in a much better position when you're trying to explain to a regulator why something, through no fault and through no lack of reasonable efforts went missing, or to opposing counsel who's saying they're trying to get rid of evidence. That's going to put you in such a better position. And ultimately, it comes down to also, it's going to help you understand your information. It's forcing you to be proactive, going back to Dean's point earlier, which frankly, humans, we're not predisposed to be proactive. But it forces you to be. And so once you better know your information and where it's stored and who has it, the more efficient you're going to be to A, preserve it, B, understand it, and C, ultimately process and produce it in a timely fashion.
So I agree with all of that, 100%. All of that's true. Everybody take that all in. But I will add a little asterisk. We know that today's day and age with the variety and all the different types of data and the challenges that come with it, especially on the IG side, organizing all of that. If you do come across something and you don't have the policies and everything in place, we as an eDiscovery universe on the technology side have come up with very clever ways to manage these hair on fire, really tough cases that require this. I'll tell this. I'll give an example. We had a case where C-suite executive deleted everything off the device. The judge got pretty upset about that. We checked backups. There were no backups. Literally, that person had none of the data. So what did we do? We had to put our heads together, and we determined or talked to the custodian and said, hey, who did you know, or who did you maybe talk about this to? And so instead of the custodian, we went to all 100+ people that person was texting with and collected all of their devices to restructure it. So yes, if you don't have right policies in place, things like this can happen, but just know it comes at a premium. It was a very expensive case, one phone versus over 100. So just keep that in mind.
That's amazing. Yeah, and Rick, I think that's a great point, because all of this, we always talk about people, process, and technology, right? That's a perfect example, right? You want to have the people who are engaged and who are on this call, who are actively learning, educating themselves, and evangelizing across the organization. You want to have processes and policies in place, but then ultimately, as a fail-safe, thankfully, people like you and Dean have technologies, and their company and your respective companies have technologies that can kind of save when people and process do fail.
Yeah, great point.
Yeah, thank you all. I think, again, talking about the technologies, I know that not all organizations have the budget for the next, the latest and greatest. Actually, we do have some organizations still kind of managing various processes, policies, legal holds, et cetera, on spreadsheets. But, aside from that, how can companies, of all sizes, make sure that their data that they're collecting, exporting, et cetera, how do they stay compliant with and or without technologies from your perspective?
I'll jump in on this one because I think Matt just talked about it, and it kind of crystallized for me that the one thing I think you need to do right, first and foremost, is around legal hold. Because if you can't preserve well, first of all, there's notices and then there's actually preserving. But that notification process where you tell custodians not to delete anything, and then the actual making sure you don't technologically delete things is foundational. Because to Rick's point, yeah, you may be able to reconstruct it, you may not be able to. You just don't know.
Right.
And and in that litigation context, you're on the back foot and you're in trouble with the judge and the opposition's salivating about all the stuff you did wrong, and that's just not where you want to be. That is not that hard or that expensive. I mean, that level of software and processes and technology is, call it 25 to 50K for your organization. And you can just do that and do that well. Everything else downstream that you may or may not do as well is going to be contingent upon that one first step. And so I would say, look, there's kind of like no excuse not to have a sound and well-used and legally defensible legal hold process. Matt talked a little bit about that. And then the question's a little bit on sort of the chain of custody and authentication, and there's a bunch of other downstream things, and that's probably where Rick and team and like actual, eDiscovery vendors who handle data want to make sure that's admissible is kind of a separate thing. Rick, I'm sure you've got thoughts on that.
Yeah, I do, but I'll save. I've got another point that I'll talk about here in a little bit.
Yeah, I'll just add on to that. I mean, I think it's so the process is, obviously we've mentioned it, you want to have a legal hold process, but even before that, from an information governance standpoint, and I think this takes us back to the first two slides, it's really just organizing your house, right? And there's a myriad of reasons to do it beyond the collection and exporting, which are huge, and having an idea of what you may need to produce. And I think ultimately, once an organization reaches a certain level of maturity, it has a sense of when and how it will be sued or investigated, right? Not always. There's going to be those lawsuits that come about that maybe they're out of left field. But for the most part, there's a certain predictability or cadence to litigation and certain intuitiveness to it, which means that knowing that you can better organize your information. Well, this information, needs to be kept in a state where we're ready to produce it if we need to, because it's exculpatory, or we know it's going to be the crux of an investigation or litigation. And so you have a certain sense of what needs to be preserved. But this goes to, I think, in some of the technologies that Gimmal has and that CloudNine has, is is organizing information before you have to run and produce it in litigation or for an investigation. And there's a ton of benefits to it, obviously. I mean, I think it's fairly commonsensical that organizing things is going to make you more efficient as an organization, but there's also a lot of compelling reasons to do so as well. So one of the things we've seen in litigation when it comes to trade secret is organizations that are a little bit haphazard in the way they manage information can avail themselves of trade secret sometimes protections, because if you don't take reasonable steps to preserve something and to secure it, I should say, then you can waive those protections. So an analogy is if Dean, has a ground level apartment in New York City with a lot of foot traffic, and he leaves his window open and his beautiful Rolex watch sitting on the windowsill, and it gets stolen. Well, he, probably could have expected that was going to happen. If you, as an organization, have very confidential trade secret sauce information, and it's just sitting somewhere on your J drive in unstructured format with no access restrictions, well, when you go, if that ultimately is exfiltrated or somebody takes that information and goes to another company and you claim trade secret, you're putting yourself and the company at risk from a defensibility standpoint or a prosecutorial standpoint because you didn't take reasonable steps. So things like categorizing information, classifying that information by confidentiality stratas, and just having a better sense of how that information exists within the organization has those benefits. And then when you get to eDiscovery, have those knock-on benefits of knowing, okay, here's what we need to really identify scope and then ultimately be able to preserve and produce if necessary.
Yeah, and Matt, that caused me to think a little bit about, like, eDiscovery is one reactive process that happens. There's also data subject access requests. There's also internal investigations. There's also mergers and acquisitions. There's intellectual property you talked about. There's a wide variety of things where it's like, I need to go grab some data for a very specific purpose.
Mm-hmm.
And you just don't want that to be a fire drill. And so what ends up happening is a series of painful fire drills cause people to then get better hygiene, sadly. But increasingly, we're not just doing this for eDiscovery, we're doing it for lots of different processes.
Yeah, the ounce of prevention is worth a pound of cure here, right?
Rick, I wanted to circle back to you with your thought if you had any, you were mulling it over.
Well, it sort of segues into the next slide. So
yeah.
So I appreciate the Tia, but so anyway, I'll cover it here.
Awesome. Well, so, I'm listening to you all, and I'm kind of also having my own triggers. I started off my career, my first job out of college was at a boutique media litigation firm. So I spent a lot of days and late nights in a small cramped room. I mean, literally highlighting emails, printed out emails to review to help various cases. And so I'm wondering, in terms of data review analysis, how are your clients, or in your experience, how are folks modernizing it with traditional methods, but also, trying to leverage new technologies or even AI to help speed this up?
So this is where it gets tricky. And I'll go back to the Wayback Machine of early days of eDiscovery. We were, as a technology company, trying to solve the challenges of email and files, right? So very reactive. We had terabytes and terabytes of data, a lot of backups. So companies and platforms like Trident Pro or Clearwell did an amazing job of culling down that data before review. So really taking down those costs. Well, what happened was then over time, these processes got into control where culling became very easy, and then documents were created of the emails and all the files for review. Well, so today's data, people are trying to do the exact same thing, but what we're finding is there's this new wave or need for a Clearwell-esque, and Clearwell, just so everybody knows on the call, it would take massive amounts of email, high duplicates because there were backups, and cull it all down to a smaller subset for a more manageable final review to run productions. Well, what we're finding today is you'll take all your cell phone data, your Slack data, your Teams, your emails and everything, convert them all to documents and try to run through a document review. Well, the challenge we're finding there is multifold. one, context. Can we see by breaking everything out into documents where Matt and I start a conversation over email, then we might switch over to Slack, then pick up our phones and start texting. Like, how do you see cross-channel communications managed well, right? The other thing about that is the cost. So converting everything to images on the front end is extremely costly from a processing side. And then the review certainly becomes very tedious. You're drawing a lot of redaction boxes, et cetera. So what we're finding is that today, this is data, not documents, right? So we will produce documents at the end. We'll talk about that here shortly. So yes, we will always keep the documents, but the review doesn't have to do that. Near native reviews of modern data is becoming more popular, and very few platforms on the market to do so. CloudNine certainly being one of them, not trying to plug necessarily, but it is a methodology shift because everyone does like to just throw everything into documents and try to run it through the same process. But where I'm at today is there are better, faster, more efficient ways to do this. We had a client throw us, hey, we have 16 gigs of JSON files out of Slack. Can you just put these all into your review platform and we can review everything? And we said, well, okay, we could, but it's 80 million messages. And so what we found was through a quick exercise of determining who and what channels, we took the 80 million was less than 1 million. What was supposed to take months to review was done in 3 weeks with just a handful of attorneys. So there are more efficient ways to manage the modern short message communications, and then layering in social media, geolocation, all those elements can be important as well. So so traditional document review may not necessarily be the answer. So it might be good to look at other options.
Yeah, Dean, Matt, anything from your perspective or?
Yeah, I think maybe that's some great points, Rick. This is also, I think, something that surprises a lot of practicing litigators is that the amount of time it takes now to get something into a usable format. And they don't think about it, right? I mean, they're I can speak from the litigation side. They're thinking about prosecuting the case, right? And the evidence will be there. And we'll, when I go to my 26F in federal court or I do my meet and confer in state court, we've preserved information and we'll be able to produce this. But the fact that you need to be able to review and analyze it, and that it takes more time because there is so much of a variety of information, and sometimes it's not readily available or easy or to put into a format where it can be reviewed in any sort of discernible manner. That needs to be something that you're thinking about as an organization ahead of time, right? Because the vast majority of corporate litigation or organizational litigation is reliant on communications, right? Emails, chats, text messages, what we say, how we say it, when we say it. That's all the most relevant information typically. And so you need to be able to identify those conversations. If, to your point, Rick, you've got, what was it, 6 million or however many items of dialogue, you need to parse that down. Now, there's technologies that are coming online and a lot of AI that is finally, at long last, proving the promise that it's long held. But that still, you have to be able to identify what you're going to point the laser at, if you will. And that takes a lot more time, a lot more planning. And from an organizational standpoint, you're really putting yourself at a defensibility disadvantage if you haven't thought about this ahead of time from, again, the left side of that EDRM, and organizing and identifying information, and maybe even calling down that information by getting rid of email on a regular cadence or routine cadence, or getting rid of Slack messages after 30, 60 days, so that you're not, so you can sort of separate the wheat from the chaff. If you're not thinking about it as an organization, you're putting your litigation counsel at a competitive disadvantage, I think.
All good things to mull over and think through. I think, we're good on time here. So kind of last words, future forward, thinking here, any emerging standards, trends. I mean, obviously privacy laws, regulations constantly coming out, so it's overwhelming for folks. And not everybody, as you all shared, not everyone can be proactive. And so how can we balance that process policy and still kind of be nimble and flexible?
Yeah, I think it's I think that's where the technology has to come in to satisfy the broad types of requests for, let's just say, productions. So the data needs to be produced to the opposing counsel, to the government agency. That we understand should definitely be documents, right? But we're getting requests like, well, I want a PDF of all but I want all messages on there, and I want the ones that are non-responsive or confidential redacted. Cool. We could, we can do that from a technology standpoint. Or I want a thread, this is less popular, but I want a thread that only contain responsive messages, and the ones that are non-responsive are just as if they never existed, right? So from a technology standpoint, platforms need to have all the options to handle all the arguments that everyone out there is making in court, and to make sure that we can satisfy the production requests. And reasonableness certainly is a big part of it. So if you don't have the right technology, there might be another reasonable way to do it. But I will just say, technology has made it easier. I was having a conversation at a conference last week, and I was like, I think our legal industry is super spoiled. They have access to all this great technology. A lot of it now is, case-based consumption as far as a pricing model. So there's easy ways to go about this, but change in our industry is seemingly difficult in some ways. And so we recognize that. So technologies just need to accommodate the various workflows there.
There's a question, and it's a little off topic, but I think related, especially with just a few minutes out here. But I heard you all mention HR and policies. Can you dive deeper into that a little bit? From what I'm gauging from this question, is, it sounds like these policies or data production and, across the litigation lifecycle is produced by people. And so how have you all, from your experience and backgrounds, worked with HR or haven't worked with HR to help this?
Let me hit one really quick, and then I think Matt will probably have a lot more on this one. But the one to me that's critical to start with is, what are, and this is both HR and kind of IT, what are officially sanctioned ways to communicate and do business? And so if that's to me foundational, so that if you're standardized on team and somebody's using Slack like rogue, which they can do now, we didn't really get to talk about remote work and BYOD and all the sort of problems that caused, but there's ideally a small set of officially sanctioned tools and communication things that are used. And I think that's a policy you need to have locked down. So ideally, what you want to say is, if somebody's sending text messages to customers, that's just not sanctioned. It's not allowed. We don't keep it. We don't track it, et cetera, et cetera. It's not always a perfect sort of defense. But I would start with that, because if you don't do that, it's just, and everyone does what everyone wants, almost no way to keep up with all the various comms vehicles that people could use and do bad things with. And so I think that's where I would start.
Yeah, that's a great point, Dean. There's a tension there, right? We don't want to be Big Brother, right, as an organization. But unfortunately, the way that things have kind of worked out with, the issues that could, be created if there's no guardrails in place, it's too high a tight wire to walk. So while we want to encourage productivity and employees to be able to use communication to facilitate that, and we want to make sure that that communication is viscous among collaborative groups, that's a great thing, right? But the tension is that by doing that, you now put the company at greater risk. So you do have to have those rules in place. HR does need to have a seat at the table when discussing what are the codes of conduct, what are the acceptable uses, what are the applications that can be used, and under what circumstances, right? It's fine. It's just like driving, right? There's a need to get places, and so we've created vehicles to do so, but you also have to have rules of the road and guardrails to make sure that the negative impacts of driving, injuries and other such things don't occur. And it's analogous here, because we want to make sure that our employees have the resources they need to operate. But at the same time, we need to be protecting the company, the organization, this, in the same vein.
One last little piece there is, if you are creating policies, make sure that if the company can follow them, because if you create a policy and they're not following it, it can really just cause problems downstream as well.
Yeah, that's a great point, Rick. And I always say this to my clients: it's better to have no policy at all than a policy that is not being followed or is haphazardly followed. So we definitely write our policies, and that's a goal of mine and philosophy, is to be as practical as possible so that the individuals will understand them, but beyond that, they can be implemented and administered and complied with.
Yeah. Well, thank you all. I think honestly, that's another topic for another webinar at some point.
Sure.
And so, well, thank you all again to everybody. And, we're just at the top of the hour here. So I think there's been a lot of good nuggets and insights. Wanted to provide a couple of ways for folks to stay in touch with us. I know that some of you all, may or may not know the panelists personally, and so feel free to reach out to them on LinkedIn. Dean will actually be at CLOC next week, and so feel free to reach out, say hello, meet in person. And Gimmal will also be sponsoring a couple of various conferences. As I mentioned, ARMA Canada in a couple of weeks, and all throughout the summertime into the fall. And so please reach out to us, gimmal.com/events. Thank you, Rick from Cloud9. Thank you, Cooley and Matt, and of course, Dean, for joining live. So thank you all again, and we will see you on our next webinar and around the block. Bye, everyone. Have a great day.
Bye-bye.
Thanks, guys.